He was accidentally shot in the head twice.
Now, bang, 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 they're gone.
Muhammad was sent home by Harris for not performing her work duties. Afeni Muhammad Dowell's manager Jennifer Harris multiple times with a kitchen knife.
These two men, they not only took my husband from me, they took my life away.
In December 1999, Sean Ryan Grell carried out a crime that horrified Arizona and made national headlines. Grell picked up his daughter, Kristen Salem, from daycare and promised to take her to see Christmas lights. Instead, he drove her out to a remote desert near Apache Junction while she was asleep in the car. There, he killed her, later admitting everything in a chilling videotaped confession.
I lit her and mixed in the car. I took the gasoline, poured it on her. Took a match and threw it on her.
Kristen tried to crawl away, but didn't survive. In 2001, Grell was convicted of first-degree murder and sentenced to death, but in 2013, the Arizona Supreme Court overturned the sentence after ruling he was intellectually disabled, which under U.S. law made execution unconstitutional. Grell's sentence was reduced to life in prison, and he remained behind bars in Tucson for over 2 decades. In April 2025, prison officials confirmed that Grell died at age 50 from natural causes linked to advanced lung cancer. The Arizona Department of Corrections noted that his death, like all in custody deaths, remains under routine review by the medical examiner. In early 2018, 23-year-old Ellen Ellie White from Westchester Township, Ohio, began receiving anonymous and unsettling messages. Over time, these interactions grew more invasive, with someone reportedly watching her through her window. Concerned for her safety, Ellen filed a police report in April. Then, on July 29th, she was reported missing. After nearly a month of searching, authorities discovered a body in a field near Milliken Road on August 24th. The area was close to the home of 29-year-old Michael Strauss, who had been a person of interest. Digital evidence, including phone records and location data, pointed investigators to Strauss. He was arrested the following day.
Mr. Strauss, this is what is known as a video arraignment. We're going to do 4 things here. We're going to tell you of the charge against you. We're going to set a bond. We're going to tell you of your next court date. Your bond has been set by the judge, Judge McDonough, at $2 million cash only.
On March 12, 2019, Strauss pleaded guilty to multiple charges, including murder and stalking. Prosecutors explained that Ellen's death was the result of a planned act, and Strauss later moved her remains to a field. On April 17th, a judge sentenced him to 17.5 years to life in prison. During the hearing, Strauss addressed the court and expressed remorse. In July 2014, 72-year-old James Rolman, co-owner of David Hirschberg Steel and Recycling Center in Lockland, Ohio, was lured away from his business under the pretense of a scrap metal deal. After withdrawing a large sum of cash from a nearby bank, surveillance footage showed another man entering his vehicle. That man was later identified as Christopher McFerrin, who led Rolman to a nearby location, fatally shot him, and took his money. Rolman's body was later discovered in the car. McFerrin, who had previously done business with Rolman, was arrested after a slow-speed chase and admitted to the crime.
Or may be aware this is an allegation of a robbery execution style murder.
He pleaded guilty to aggravated murder in Hamilton County Common Pleas Court and was sentenced to 23 years to life in prison. A second suspect, Jason Brown, age 34, was also charged in connection with the case. Prosecutors stated that Brown waited in a truck nearby while McFerrin carried out the case. Although Brown knew about the robbery, he was reportedly unaware that McFerrin intended to murder Rolman. After the incident, Brown, who struggled with heroin addiction, received part of the stolen money and used it to check into a hotel and use drugs. Brown pleaded guilty to manslaughter and was sentenced to 12 years in prison. In December 2015, Hamilton firefighter Patrick Wolterman tragically lost his life while responding to a house fire on Patter Avenue. The fire initially appeared to be accidental, but investigators soon determined it had been intentionally set. The home belonged to Lester Parker, who, according to prosecutors, was under financial stress and arranged for his nephew, Billy Tucker, to set the fire in exchange for insurance money. The blaze claimed the life of Wolterman, who fell through the floor while attempting to save the property. The investigation eventually led to charges against both men for aggravated arson and murder. In November 2017, after a week-long trial and just 2 hours of jury deliberation, both Parker and Tucker were found guilty.
We were married not even 7 months. These two men robbed me of my whole future. They not only took my husband from me, they took my life away. We didn't even get to have children yet. They took that away from me. I'm asking that you impose the maximum sentence on them for taking my whole life and future away.
During sentencing, Wolterman's widow, Bree, delivered a powerful and emotional statement, explaining how the loss of her husband had also taken away her future. They had only been married for 7 months. The judge sentenced both men to life in prison, a decision that brought a sense of justice to Wolterman's family and the firefighting community. On October 26, 2017, a tragic crash on Staffordsburg Road in Independence, Kentucky, claimed the lives of Rodney Pollett Jr., his fiancée Samantha Malone, and their 2 daughters, Haley Ann and Kaylee, and a Brendan. The family was instantly when 57-year-old Daniel Grice, driving a Honda Pilot at nearly 96 miles per hour, crossed into their lane and struck their vehicle head-on. Investigators confirmed Grice had been drinking, smoking marijuana, and was trying to pass illegally in a no-passing zone, with no signs of braking. He was returning from a golf outing and later admitted to being both impaired and fatigued. The crash left no survivors in the Pollett family and devastated an entire community.
He deserves everything he's going to get.
They were wonderful parents. Children were so young, and no, they didn't deserve any of this. They were just out shopping and headed home, so there was no reason for it. We've lost beautiful children. We've lost kids that did not use drugs. They didn't drink. They took care of their kids. They were not wealthy, but they were very much in love, and they were very happy.
Grace was seriously injured in the crash, but was soon charged with 5 counts of wanton murder. In court, prosecutors revealed his blood alcohol level was 0.089 and THC was present in his system. Clear evidence of reckless disregard for human life.
What was the speed 1.5 seconds prior to impact?
85 miles per hour.
What was the speed a half second prior to impact?
92 miles per hour.
It's accidents or things that can't be avoided. This was something that most definitely could have been avoided, should have been avoided, never should have happened. The Pollett family should still be with us.
Rodney was a family man.
In 2018, a jury found him guilty, and on August 27th, Kenton County Judge Patricia Summey sentenced him to 20 years for each count to be served concurrently. Under Kentucky law, Grace is eligible for parole after 17 years. In March 2002, 19-year-old Nolan Moy was fatally shot during a home invasion at his residence on Erie Avenue in Madisonville, Ohio. The young man was killed in his own bedroom during what appeared to be a robbery gone wrong. Despite initial efforts, the case went cold for 7 years, leaving Nolan's family in heartbreak and uncertainty. Each year, his mother publicly pleaded for answers, determined to keep her son's memory alive and the case in the public eye. In 2009, a friend of the suspect finally stepped forward with information that led authorities to William McNally, who was arrested and charged with Nolan's murder. McNally later confessed that after spending a night using drugs and running low on money, he chose to rob someone he knew, Nolan, because he had broken into the house before. But when Nolan unexpectedly woke up, McNally pulled the trigger. In court, McNally expressed remorse, claiming he never intended to hurt Nolan.
Thugs broke into Nolan's house, into Nolan's room, finding Nolan had nothing. He was accidentally in the head twice.
I'd like for you to picture in your mind your son, your grandson, your brother, your nephew or cousin. Do you see them clearly in your mind? Now, bang, 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 they're gone.
My dear sweet Nolan, my heart is broken today.
In all my experience being a defense attorney, a prosecutor, and a judge, I've never seen so much support for a victim as I have in this case. The letters and the people here are overwhelming. And what that simply tells me is that this was a unique young man who touched many lives whose life you have put out.
In a packed courtroom years later, Nolan's grieving family shared heartfelt memories and grief, describing him as a talented, loving young man whose life barely had time to begin.
He's been for 8 years and still has an entourage. I believe that speaks for itself about what kind of person Nolan was. And then William McNally, after getting high all night at Annie's and being a little short on money, decides to rob someone in the middle of the night. And he knows exactly where to go. Because he's done it twice before.
Not only did you take Nolan by and he's gone now, but you've taken away a part of the rest of my life. You've taken away a part of the rest of everybody's life.
Thugs broke into Nolan's house, into Nolan's room, finding Nolan had nothing. He was accidentally shot in the head twice.
I'd like for you to picture in your mind your son, your grandson, your brother, your nephew or cousin. Do you see them clearly in your mind? Now, bang, 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 they're gone.
My dear sweet Nolan, my heart is broken today.
In all my experience being a defense attorney, a prosecutor, and a judge, I've never seen so much support for a victim as I have in this case. The letters and the people here are overwhelming. And what that simply tells me is that this was a unique young man who touched many lives, whose life you have put out.
McNally was sentenced to 16 years in prison with no chance of early release, a decision the judge said reflected the overwhelming community support and the devastating impact of his actions. In 2009, the death of Chloe Sensman led to the arrest of her father, Benjamin Sensman, in Hebron, Kentucky. Authorities charged him with second-degree manslaughter and criminal abuse, claiming he was responsible for the girls. A year later, in 2010, Sensman was convicted and sentenced to 15 years in prison. However, many of his neighbors were stunned by the allegations, describing him as a kind and devoted father they regularly saw caring for his daughter.
When that story or that fact arose on the street, people were shocked. There's no way, not Ben. Not Ben. Ben's a nice man. We see Ben every single day with his kid.
In 2013, the Kentucky Court of Appeals overturned Sensman's conviction, ruling that his confession had been coerced and that he wasn't properly advised of his right against self-incrimination.
Give him another trial. I think it needs to be looked at. I think there were things missed in his character.
Facing a retrial, he entered an Alford plea, maintaining his innocence but acknowledging that the prosecution had enough evidence to likely secure a conviction. The charges were reduced to reckless homicide and second-degree abuse. Sensman received a 6-year sentence with credit for time already served, making him eligible for release within 4 years. In August 2023, Jake Kelly was staying at a home in Phoenix with Corey and Shannon Young when things took a deadly turn. Police say Angel Malooly assaulted Kelly, leaving him hurt and unconscious in the driveway. Instead of calling 911, the Youngs carried Kelly inside, put him in a bathtub, changed his clothes, and waited nearly a day before finally taking him to the hospital. By then, it was too late. Kelly died days later from his injuries, and the delay in medical help became a key part of the case. Over the following months, Corey Young pleaded guilty to hindering prosecution and was sentenced to prison, while Shannon Young received probation.
You had different things that were contributing to why Mr. Kelly passed away. There was obviously not immediate medical attention for the injuries. Number two, you also had a situation where all of the critical witnesses were highly intoxicated.
Malooly, who was the only one directly charged with causing Kelly's death, struck a plea deal to reduce his charge from murder to manslaughter because witnesses were highly intoxicated and the facts were murky. In May 2025, Malooly was sentenced to 8 years behind bars. In August 2006, David and Liz Carroll reported their foster son, Marcus Fiesel, missing from a park in Clermont County, Ohio. The story initially sparked a large community search effort, but investigators soon uncovered a much darker truth. Marcus had not gone missing. He had days earlier after being left unattended in the family's home for several days, while the Carrolls attended a weekend festival. When they returned and found that something had gone wrong, they attempted to cover up the situation by creating a false story about his disappearance. The shocking details emerged through witness testimony and investigation, exposing severe neglect and leading to criminal charges. In 2007, David Carroll pleaded guilty to murder and gross abuse of a corpse, receiving a sentence of 15 years to life, while Liz Carroll was found guilty at trial and sentenced to 54 years to life. Nearly 16 years later, in 2023, David Carroll applied for parole, but the Ohio Parole Board denied the request. They cited his lack of remorse, poor behavior in prison, and concern that he posed a continued risk to society. With parole denied, Carroll will remain incarcerated and won't be eligible for another review until 2032. In April 2015, Kelsey Crowe, a promising student and athlete at Purcell Marion High School in Cincinnati, was shot while attending a party at the Melrose YMCA in Walnut Hills. As the event was ending, shots were fired outside the venue, and Kelsey was struck while trying to leave. She was taken to hospital, but sadly passed away the next day. The shooting, believed to involve multiple individuals, sent shockwaves through the community and sparked a lengthy investigation. For nearly a year, her family, friends, and school waited for answers as police worked to identify a suspect. In April 2016, nearly a year later, Rico Mosley, then 19, was arrested and charged with murder and felonious assault.
Knowing that they caught the person, it still seems like a relief and like unreal, because now she can rest in peace.
I was kind of losing hope because it's been almost a year and I can't believe it took that long for anyone to speak up.
We are very grateful for the officers who have been working on this case, that they have not given up. I can say that for Kelsey's family as well, I'm sure. To have something happen with the case, with an arrest, brings a sense of relief. It begins to bring a sense of closure to the situation.
Prosecutors alleged he was involved in the shooting that took Kelsey's life. His bond was set at $800,000, later raised to $1.5 million. However, Mosley's defense argued that there was no physical evidence, no weapon, no fingerprints, no DNA connecting him directly to the crime.
People wanted answers for this particular murder. They wanted answers. They wanted somebody to be blamed. They wanted somebody to be responsible. So Cincinnati got them a man. Now that's what happened in this case. The social community pressure precipitated the charge today.
During the trial, a witness claimed to have seen Mosley shooting, but questions remained about the chaotic scene and involvement of other shooters. In the end, the jury found Mosley not guilty, leaving many still searching for justice in a case that had already caused deep pain and loss. In 2016, Shelley Carter of Middletown, Ohio, was going through a difficult divorce and feared losing custody of her sons and her home. In a desperate move, she approached a man with an offer, $1,000 and an SUV to stage a deadly crash that would kill her estranged husband, Christian Carter. Shockingly, she allegedly told him to go through with it even if her sons were in the car at the time. Instead of carrying out the plan, the man went to the police and an investigation was launched. Authorities later revealed that two others, Casey and Sarah Fryman, were also involved in connecting Shelley with the would-be hitman.
This time, how do you wish to plead?
Guilty.
In January 2017, Shelley Carter pleaded guilty to attempted conspiracy to commit aggravated murder. Though initially emotional and hesitant in court, she admitted to planning the crime.
To hiring someone to murder my husband.
On February 23rd, she was sentenced to the maximum of 8 years in prison. The Frymans were also convicted and each received a 6-year sentence. Prosecutors and the victim's family pointed out the disturbing nature of the plan, especially its disregard for the safety of the sons. In August 2013, emergency crews were called to a North Fairmount apartment in Cincinnati, Ohio, where Robin Cottingham was found unresponsive in her crib. A concerned housing worker had requested a welfare check. Tragically, the girl was pronounced the scene. Days later, the Hamilton County coroner classified Robin's death as a homicide. The girl's mother, Janicia Cottingham, became the primary suspect, and a grand jury later indicted her on charges including aggravated murder, and felonious assault. As the legal process unfolded, concerns were raised about Janicia's mental health. Initially found incompetent to stand trial, she was ordered to receive treatment before the case could move forward. In May 2015, she accepted a plea deal, pleading guilty to involuntary manslaughter, endangerment, and felonious assault. The more serious murder charges were dropped in exchange for her plea, and she was sentenced to 20 years in prison. In May 2001, Alyssa Turney vanished after leaving school with her stepfather, Michael Turney, in Paradise Valley, Arizona. For years, the case was treated as a runaway until troubling evidence about Michael's controlling behavior came to light. In 2008, police searched his home and found weapons and explosive materials, but no clear answers about Alyssa. It wasn't until 2020 that Alyssa's sister, Sarah Turney, pushed the case back into the spotlight with her Voices for Justice podcast and viral social media posts. Her efforts led to Michael's arrest for murder, but in 2023, he was acquitted due to a lack of physical evidence. Alyssa's body has never been found. Refusing to give up, Sarah kept searching for answers and recently brought new information to Phoenix police about a Jane Doe found in Desert Center, California. Dental records didn't confirm anything, so she pushed for DNA testing, which is now underway as of May 2025.
I'm gonna try not to get too emotional, but this morning I got an email saying that they're going to, as in the Phoenix Police Department is going to move forward with facilitating testing for the remains of a Jane Doe that was found that may be a match to Alyssa. And finding out this news this morning is just so exciting. Even if it's not Alyssa, it's amazing that her legacy in this journey might bring someone back home to their loved ones.
If the remains match, it could finally bring the family long-awaited answers and possibly open the door to new legal action. Even if Michael Turney can't be tried for murder again, Sarah is also organizing what would be the first official search for Alyssa's remains, hoping that this time her sister's story might finally come to an end with the truth. In August 2013, emergency crews responded to a home on Marlowe Drive in Hamilton, Ohio, where Bryce Pelffrey was found unresponsive. He had been left in the care of Dylann Tompkins, his mother's boyfriend, while she was away. Doctors later determined that Bryce had suffered severe injuries. During the investigation, Tompkins admitted to using excessive physical force on the girl. The disturbing nature of the injuries quickly shifted the case from a medical emergency to a criminal investigation. By July 2014, the case went to trial, and Dylann Tompkins was found guilty of murder and felony endangering. A Butler County judge sentenced him to 15 years to life in prison. In the early hours of October 5th, 2017, police were called to Pendery Alley in downtown Cincinnati after multiple 911 calls described chilling screams and the sound of someone being slammed.
She's screaming again. Help, help. Lots of screaming.
We hear somebody being thrown up against a fence.
She's screaming like she's struggling, and I'm hearing bottles breaking.
Officers arrived within minutes and found 47-year-old Tracy Haws dead in the alley, with signs that she had suffered a violent attack. Neighbors described hearing glass bottles breaking and Tracy pleading for help, but by the time police got there, it was too late. A week later, on October 12th, police arrested 61-year-old William Sanford and charged him with Tracy's murder.
Now he's just really struggling, Your Honor, so I would suggest to the court that his best treatment would be at a hospital and be out of this facility.
Sanford, who appeared frail in court due to lupus and type 1 diabetes, needed help walking, and his lawyer argued he should be treated in a hospital instead of jail. Prosecutors pushed back, pointing out Sanford's violent record, including a 2005 conviction for beating a woman with a weapon, an assault so severe that officers had to force entry to stop him.
He was arrested on this murder case. The defendant spat in the face of a police officer during transport to the police car.
The judge set Sanford's bond at $500,000 while the investigation continues. He remains in custody as the community waits for answers about why Tracy Haws lost her life that night.
So you face 4 counts this morning. Count 1 is motor vehicle homicide. That is a Class 2 felony. If you are convicted, sir, you face the following potential penalty: a maximum up to 50 years imprisonment and a minimum of 1 year imprisonment. Count 2, sir, driving under the influence, causing serious bodily harm. Sir, that is a Class 3A felony. That subjects you to the following potential penalty: a maximum up to 3 years imprisonment and 18 months of post-release supervision, or a $10,000 fine, or both. Sir, there is no minimum for imprisonment and 9 months of post-release supervision if imprisonment is imposed. Sir, I will tell you also that there are other issues. You have the ability to have probation if it would be determined to be appropriate, and with no probation, you face those allegations or those potential penalties. Do you understand that, sir? Count 3, sir, is failure to stop and render aid. Sir, that is a Class 3 felony, and that subjects you to the following potential penalty: a maximum to 4 years imprisonment and 2 years of post-release supervision, or a $25,000 fine, or both. There's no minimum for imprisonment and 9 months of post-release supervision if imprisonment is imposed. Sir, do you understand the nature of the charges you face this morning and the possible penalties? Preliminary hearing.
December 1st, 2018, approximately 5:35 p.m., the defendant runs a red light at 144th and Harrison, collides with the passenger side of a vehicle being driven by Clifford Cannaday, in which Trevor Cannaday is a passenger. The defendant fled the scene on foot after the collision. Law enforcement began investigating with respect to the collision. The passenger, Trevor Cannaday, ultimately died of injuries sustained in that collision, from blunt force trauma to his chest, head, and abdomen. The driver, Clifford Cannaday, had facial injuries, a fractured sternum, and internal injuries. He remains hospitalized at this time. Law enforcement began investigating to determine who was the potential driver of the run vehicle. Eventually identified some parties they believe may know where the whereabouts of that party. They do encounter Jeffrey Egling walking on foot a short distance from the collision approximately 2 hours later at 7:43 p.m. He appears to be under the influence of alcohol. He does eventually make some admissions to driving the motor vehicle and fleeing due to having prior DUI charges. He is given a data master test with a result of .103 at approximately 8:56 p.m. Law enforcement further does a search warrant for the airbag control module on his vehicle. The initial information there would indicate he is going 69 miles per hour, a half a second prior to the crash in a 45 mile an hour zone. The defendant has prior DUIs, September of 2005 in Douglas County, September of 2016 in Douglas County, May of 2016 in Arizona, and he has an operating a vessel while intoxicated out of Missouri in September of 2012. Due to the defendant's significant history of DUIs and his flight here in connection with this offense, I think a significant bond is warranted. He presents as a flight risk. I'd ask bond be set somewhere in the range of $750,000.
Released this morning. Bond will be set at $750,000, subject to the following terms and conditions. In the event that he would make that bond, he will be required to wear a scam bracelet at all times he would be released. He will not leave Douglas County, Nebraska for any reason without an order of the court. In addition to that, he will have no direct or indirect contact with any of the witnesses. With that, he is excused.
Thank you.
Thank you. You may, sir.
I want to apologize from the deepest part of my heart for driving reckless and intoxicated that evening. I take full responsibility for my reckless behavior. There is no one to blame but myself.
Now there is a hole in my heart that will never heal. A weight on my soul that will never leave me. I listened to the words that he spoke today, and they are hollow to me. As I just stated, this has happened 4 prior times. Spent time in jail.
No one should ever again have to hear the 4 most devastating words ever put together because of the defendant. Those words are not viable for life. No parent should ever again have to watch their child gain their wings because of the defendant's actions.
On the evening of December 1st, 2018, Jeffrey Egling ran a red light at the intersection of 144th and Harrison in Omaha, Nebraska. Driving at approximately 69 miles per hour in a 45 EMF zone, he crashed into a Nissan Maxima carrying Clifford Canaday and his son, Trevor Canaday. The impact was devastating. Trevor, who was riding as a passenger, suffered critical injuries and later passed away. Clifford sustained multiple injuries and was hospitalized. Instead of stopping, Egling fled the scene on foot. He was located 2 hours later, less than a mile from the crash site. Officers noted that he smelled of alcohol and appeared impaired. During questioning, Egling admitted to being behind the wheel and fleeing the scene out of fear, aware that he had prior DUI convictions. A breathalyzer test conducted that evening revealed a blood alcohol concentration of 0.013, exceeding the legal limit. Investigators also retrieved data from the vehicle's airbag control module, confirming the high speed at which he was traveling before the crash.
December 1st, 2018, approximately 5:35 p.m., the defendant runs a red light at 144th and Harrison, collides with the passenger side of a vehicle being driven by Clifford Canaday, in which Trevor Canaday is a passenger. The defendant fled the scene on foot after the collision. Law enforcement began investigating with respect to the collision. The passenger, Trevor Canaday, ultimately injuries sustained in that collision from blunt force trauma to his chest, head, and abdomen. The driver, Clifford Canaday, had facial injuries, a fractured sternum, and internal injuries. He remains hospitalized at this time. Law enforcement began investigating to determine who was the potential driver of the run vehicle. Eventually identified some parties they believe may know where the whereabouts of that party. They do encounter Jeffrey Egling walking on foot a short distance from the collision approximately 2 hours later at 7:43 p.m. He appears to be under the influence of alcohol. He does eventually make some admissions to driving the motor vehicle and fleeing due to having prior DUI charges. He is given a data master test with a result of .103 at approximately 8:56 p.m. Law enforcement further does a search warrant for the airbag control module on his vehicle. The initial information there would indicate he was going 69 miles per hour, a half a second prior to the crash in a 45 mile an hour zone. The defendant has prior DUIs, September of 2005 in Douglas County, September of 2016 in Douglas County, May of 2016 in Arizona, and he has an operating a vessel while intoxicated out of Missouri in September of 2012. Due to the defendant's significant history of DUIs and his flight here in connection with this offense, I think a significant bond is warranted. He presents as a flight risk. I'd ask bond be set somewhere in the range of $750,000.
Thank you. Mr. McNall, I'll hear from you then, sir.
Thank you, Your Honor.
Egling was arrested and appeared in court days later.
Sir, you face 4 counts this morning. Count 1 is motor vehicle homicide. That is a Class 2 felony. If you are convicted, sir, you face the following potential penalty: a maximum up to 50 years imprisonment and a minimum of 1 year imprisonment. Count 2, sir, driving under the influence, causing serious bodily harm. Sir, that is a Class 3A felony. That subjects you to the following potential penalty: a maximum up to 3 years imprisonment and 18 months of post-release supervision, or a $10,000 fine, or both. Sir, there is no minimum for imprisonment and 9 months of post-release supervision if imprisonment is imposed. Sir, I will tell you also that there are other issues. You have the ability to have probation if it would be determined to be appropriate, and with no probation, you face those allegations or those potential penalties. Do you understand that, sir? Count 3, sir, is failure to stop and render aid. Sir, that is a Class 3 felony, and that subjects you to the following potential penalty: a maximum to 4 years imprisonment and 2 years of post-release supervision, or a $25,000 fine, or both. There's no minimum for imprisonment and 9 months of post-release supervision if imprisonment is imposed. Sir, do you understand the nature of the charges you face this morning and the possible penalties?
Prosecutors charged him with 4 felonies: motor vehicle homicide, DUI causing serious bodily injury, failure to stop and render aid, and reckless driving.
No pretrial release this morning. Bond will be set at $750,000, subject to the following terms and conditions. In the event that he would make that bond, he will be required to wear a scam bracelet at all times he would be released. He will not leave Douglas County, Nebraska for any reason without an order of the court. In addition to that, he will have no direct or indirect contact with any of the witnesses. With that, he is excused.
Thank you, Your Honor.
Thank you.
Excuse.
You may, sir.
His lengthy history of alcohol-related offenses, including multiple DUIs from Nebraska, Arizona, and Missouri, prompted the court to view him as a significant flight risk. The judge set bond at $750,000. In court, Egling eventually pleaded no contest to the charges. During sentencing, he expressed remorse, calling himself a coward for leaving the scene and acknowledging the irreversible harm he caused.
I want to apologize from the deepest part of my heart for driving reckless and intoxicated that evening. I take full responsibility for my reckless behavior. There is no one to blame but myself.
Trevor's father, Brian Canaday, delivered an emotional impact statement describing the unbearable loss of his son and the deep emotional weight it left on their family.
Now there is a hole in my heart that will never heal. A weight on my soul that will never leave me. I listened to the words that he spoke today, and they are hollow to me. As I just stated, this has happened 4 prior times. Spent time in jail.
No one should ever again have to hear the 4 most devastating words ever put together because of the defendant. Those words are not viable for life. No parent should ever again have to watch their child gain their wings because of the defendant's actions.
The court sentenced Egling to 43 to 53 years in prison, with the possibility of parole after serving more than 2 decades. The sentence reflected not only the severity of the crash, but also Egling's repeated history of impaired driving and his decision to flee instead of helping those injured. On the morning of July 10th, 2025, a fatal occurred at a restaurant on 9 Mile Road in East Point, Michigan. Afeni Badu Muhammad, a 26-year-old employee, had been sent home earlier in the day by her manager, Jennifer Harris, for not fulfilling her work duties. Before leaving, Muhammad allegedly told Harris that she would be back. After driving to a nearby park, she retrieved a weapon from her vehicle, covered her face with a hooded mask, and returned through the back entrance of the restaurant. Inside, she stabbed Harris in front of other employees. A customer in the drive-thru, armed with a licensed firearm, intervened by firing a warning shot and holding Muhammad until police arrived. Harris, who was unarmed, later died from her injuries at the hospital. Muhammad was immediately arrested at the scene.
Yes, Your Honor. 7/10/25, McDonald's employee Afeni Muhammad, McDonald's manager Jennifer Harris, multiple times with a kitchen knife at the McDonald's restaurant at 179219 Mile. Harris was not armed at the time and died of her injuries. Prior to the scene, Muhammad was sent home by Harris for not performing her work duties and told Harris, "I'll be back." Muhammad was arrested on scene and the knife was recovered. Muhammad admitted that she intended to kill Harris and stated that after she was sent home, she drove to a nearby park, decided to come back and stab Harris with a knife that she had inside of her vehicle. When Muhammad returned to Harris, she entered the back entrance with a hooded mask over her face in an attempt to conceal her identity and attempted to flee the scene after the stabbing, but was stopped by an armed customer.
And the requested charges are murder in the first degree, count 2, dangerous weapon, carrying with unlawful intent, and there's a habitual second notice offense. Is that correct?
That is correct, Your Honor.
The warrant is being signed and we can proceed to arraignment.
Thank you, Your Honor.
During questioning, she confessed to intending to kill Harris, admitting she had planned the attack after being sent home.
Very good. You're here today for arraignment on the charges of murder in the first degree, premeditated, count 2, carrying a weapon with unlawful intent, and a habitual second notice. Mr. Licata, how does your client wish to proceed?
Thank you very much, Your Honor. At this time, my client is asking the court to enter a not guilty plea. This matter set for a probable cause conference of the preliminary exam. I have advised my client of her rights, as well as the charges against her and the potential penalties. We are ready to proceed on those grounds.
Very good. Ma'am, do you understand the nature of the charges against you to your satisfaction after talking to your attorney?
Yes.
Very good. I will go ahead and enter a not guilty plea on your behalf. Are you requesting a court-appointed attorney?
She was charged with first-degree premeditated murder, carrying a dangerous weapon with unlawful intent, and was also designated a habitual offender due to a previous conviction in Virginia.
Thank you very much, Your Honor. Just briefly, my client is 26 years old, does live in the great city of East Point. Your Honor, my client is a high school graduate. In fact, is actually was taking some online classes for college for a physical therapy degree. Your Honor, there are some disturbing facts in this particular matter, but there are facts that haven't been brought out yet, and my client is extremely anxious to have those facts brought to light during the pendency of this case. She was in an extremely abusive relationship that was not only mental but physical, that involved alcohol issues, which is where the habitual second stems from, and her prior record. Your Honor, my client is a helpful person. She's a giving person. She's actually is credited with saving a life because of a who had skin cancer that she may go to the doctor to find out that that's exactly what it was, and that person is doing extremely well right now. I understand the facts that have been laid out today in the warrant, but at this time, Your Honor, we are asking the court to consider a bond in this matter that is appropriate, that my client can meet so that she could meet with her attorneys and prepare her defense in this matter. Thank you.
At her arraignment on July 11th, Muhammad's attorney entered a plea of not guilty and requested a court-appointed lawyer. Despite arguments in her defense citing her educational background, past trauma, and claims of past good deeds, the court found the charges too serious to allow bond.
To court rule, the court is well within its authority to grant no bond involving any case involving murder. In this case, we are requesting no bond for this defendant. Also provided within the court rules are certain factors for this court to consider when determining whether to grant any bond at all, and in this case we are requesting no bond as I indicate. First of all, the court can consider whether or not this defendant is a threat to the community. She entered a public building with other individuals, other employees that were present. She produced a weapon that was longer than 3 inches, and she stabbed the victim multiple times, up to possibly as many as 15 times, eventually causing her death. There were other employees that were present at the time, some of which attempted to help the victim after the stabbing occurred. That alone is enough to show that there is a threat to the community. She then ran from the building to her vehicle, presumably with the intent to flee from the scene. She was stopped by a helpful bystander. You're also able to consider the likelihood of conviction in this case, given the facts as laid out by Detective Showers and the information that the prosecutors have reviewed in order to charge this defendant. There is a very high likelihood of conviction. And then finally, the defendant does have a prior instance of at least one that I'm aware that involved a stalking, similar obviously to the that occurred in this case involving. So given all of those factors, and given the fact that this court does have authority to give no bond to defendants charged with murder, I am asking at this time for no bond in this case.
The prosecution emphasized the premeditated nature of the crime, the presence of multiple witnesses, and Muhammad's violent criminal history.
The court has reviewed the charges and the circumstances surrounding this case. The defendant is facing various serious charges, including murder in the first degree, which is one of the most serious criminal offenses in our state, carrying penalties up to life without parole. Additionally, carrying a dangerous weapon with unlawful intent further underscores defendant's potential threat to public safety. Defendant has a prior criminal record out of Virginia for malicious wounding. It was actually felony malicious wounding that was reduced to unlawful bodily injury concerning a stalking, and that is what gives rise to the habitual second. And in determining bond, the court must look to the factors outlined in Michigan Court Rule 6.106. Number 1, the seriousness of the offense and the danger posed to the community. The charges here involved a violent crime with a weapon, indicating a substantial risk to the public. The court finds there is a significant threat to public safety, and therefore the bond must reflect that risk. Number 2, the weight of the evidence against the defendant. While the evidence is not fully before us and the defendant is cloaked with the presumption of innocence, the nature of the charges along with the prior criminal history suggests that there is substantial evidence against the defendant. Defendant's criminal history: the defendant has a violent criminal past. The history supports the court's concern that the defendant may engage in further violent conduct if she is released. The defendant's ties to the community: while the defendant is relatively young at 26 years of age, there's no indication that she has any significant stabilizing ties to the community that would ensure her return for court appearances. Without these ties, the court is concerned about the likelihood of flight. Number 5, defendant's risk of fleeing or failing to appear. Due to the severity of the charges and the habitual offender status, it makes the defendant a high risk for flight. The court finds that this factor weighs heavily in favor of a high bond amount. Substance abuse or mental treatment: although there are no reports at this time suggesting that the defendant suffers from mental health or substance abuse issues that would mitigate the risks posed by defendant's release, the court is, after considering all of these factors, going to be setting bond at $25 million, cash surety only, with conditions. If the defendant is able to meet those conditions, she must be on a GPS steel cuff tether. She is not to leave the state of Michigan. She is to report her address within 24 hours of, she must report any change of address within 24 hours. There would be stringent daily contact with community corrections as to her whereabouts. She also would be required to have alcohol and drug testing as condition of her release. There would be no contact with the family of the decedent. Any witnesses, she is not to return to McDonald's. And if she is unable to post the $25 million bond, she will remain in custody pending further proceedings. And that concludes this matter for today. We will see you back here, ma'am, on July 23rd at 1 o'clock for your probable cause conference. Thank you.
Thank you, Your Honor.
Thank you very much, Your Honor.
You're all set, ma'am.
Citing public safety concerns, the judge set bond at $25 million, cash check surety, with strict release conditions, including GPS monitoring and a ban on contacting the victim's family or returning to the restaurant. During the July 23rd probable cause hearing, the court ordered a mental health and competency evaluation, postponing the preliminary examination to September 3rd, 2025. As the case moves forward, Muhammad remains in custody at the Macomb County Jail. Jennifer Harris, remembered as a beloved manager and a mother of 6, was honored at a candlelight vigil on July 14th. A community fund was later established to support her family. In September 2022, Jacob Runyon and Chase Kaminsky were frontrunners in the Lake Erie Walleye Trail Tournament, with hopes of winning the coveted Team of the Year title and over $28,000 in prize money. Suspicion had surrounded their unprecedented streak of success throughout the season, but no solid proof had emerged until the final weigh-in at Gordon Park in Cleveland. Onlookers watched as their 5 fish, appearing to weigh 4 to 5 pounds each, were inexplicably declared to weigh over 33 pounds in total. Jason Fisher, the tournament director, sensed something was wrong and cut open the fish. Inside, he discovered lead weights and extra fish fillets, exposing a blatant act of cheating. The moment went viral, shocking the competitive fishing world and drawing widespread media attention.
Here, champions. Round of applause, you got Chase Kaminsky, Jake Runyon. We need pictures of those fish over here. Stick around a while.
You hear some of the crowd yell, "Yeah, right," as 33 pounds comes up on the screen. I would caution and warn, the next few videos will have graphic language used. they walk away, Jason Fisher has yelled, "Jake, Jake," to bring them back over. We'll see the next video from the viewpoint of looking at the fish themselves as they're cut open, with Mr. Runyon standing front and center.
We got weights and fish! Get the f*** out of here! Get the f*** out of here! Really? You're a piece of shit! You're a piece of shit! And you did it yourself! Get here! Take pictures. I need pictures.
An investigation was quickly launched by the Ohio Department of Natural Resources. Authorities confiscated Kaminsky's $100,000 boat and found evidence of tampering, including a hidden compartment.
We're back to September the 30th of last year, last fall. The Lake Erie Walleye Trail, that was the culmination of their tournament series that was hosted here on Lake Erie over at Gordon Park in Cleveland. Chase Kaminsky and Jacob Runyon were the front runners to win Team of the Year if they did well in that tournament. So the stakes were high. That day's tournament, Team of the Year, and several side pots and other bets that were all on the line. If they would have won that tournament and won Team of the Year, they would have won in excess of $28,000. That's what we're talking about. This is the end of a long season where Chase Kaminsky and Jacob Runyon had a curiously unprecedented run of success, such that other competitors, other officials of that tournament suspected foul play. They noticed some oddities, but they couldn't prove anything until Chase Kaminsky and Jacob Runyon were caught red-handed that day. It wasn't a great day for fishing. The conditions weren't great. A lot of the teams were coming in with small fish, not that many fish, and then at the end of the weigh-in, here comes Chase Kaminsky and Jacob Runyon with 5 fish that drama isn't going to be enough for them to win Team of the Year. Jason Fisher is doing the weigh-in. You're going to see this on the video. They weigh the big fish first for a big fish prize, and then all 5 fish together for the combined weight. And they need somewhere around 16 to 17 pounds of fish to win Team of the Year. 5 fish get weighed, and it's in excess of 33 pounds. Jason Fisher, very experienced, he thinks he's looking at 4 to 5 pound fish. They're weighing in at 6 to 7 pounds each. You're going to hear some of the crowd, the peanut gallery in one of these videos as the weigh-in goes on, and you're going to see the reactions before they're caught as to what everyone's suspecting. Nobody on that day could have known the sort of viral spread that this case was going to present, the outrage, not just in the fishing community, and the media worldwide attention that this case has brought. And I agree with what Attorney Gentile said, is they're forever going to be branded with the labels of cheaters and thieves.
In March 2023, both men pleaded guilty to felony cheating and misdemeanor unlawful possession of wild animals.
We are here in our case 675007 for sentencing. We're in a prior date and time. Both Mr. Kaminsky and Mr. Runyon entered guilty pleas to count 1 as charged, which is a count of cheating as a felony of the 5th degree with forfeiture specifications. Also to count 4 as charged, which is a count of unlawful ownership of wild animals as a misdemeanor of the 4th degree.
Thank you, Judge. Judge, actually, there's very little to say. I mean, we've entered a plea of guilty. We've accepted responsibility for our conduct in this matter. Judge, we did that at the earliest opportunity with the county prosecutor's office. We acknowledged our wrongdoing as soon as we possibly could. We did attempt to negotiate a positive outcome for our clients the best one we could, with the understanding that they knew what they did was wrong. You know that there's going to be a forfeiture of the boat from Mr. Kaminsky, and it's a significant punishment in and of itself, Your Honor. I know the court's well aware of the publicity that's accompanied this case, and sometimes the negative impact it's had on our clients, if you will. Probably more than many other cases that we handle in this building for whatever reason. Having said that, there are no excuses, Judge. We have entered a plea of guilty to the counts that you have before you, and we stand ready to accept whatever punishment you deem fit.
Additional charges, including attempted grand theft, were dropped as part of a plea agreement.
The ancient Greek writer Sophocles wrote, "I would prefer to even fail with honor than to win by cheating." And really, at the end of the day, you're convicted felons and cheaters. After considering the purposes and principles set forth in sentencing, and we'll find that you are amenable to community control sanctions. And for count one, would be put on Group B supervision for both of you. I'm going to impose a $2,500 fine, however, and court costs and supervision fees. I will suspend half of that fine, fees, and costs, provided that you guys make a like 1/2 charitable contribution to one of the 501c3 charitable organizations that focus on, fishing and children. There's Cast for Kids Foundation, Kids Fishing Foundation, Fish for Kids Charity Foundation, or the Ike Foundation. Any one or other of a foundation, a legitimate 501c3 organization that deals with children fishing. I will forfeit your license for the mandatory 3-year maximum. On count 4, I'll give you a 30-day jail sentence, which I'll suspend. One of the criteria that I am to consider in every felony sentencing, one of the big issues is always remorse, which I do genuinely believe that you gentlemen are remorseful. I read that in your letters to me, as I've indicated to you, and I do believe that. But there is a consideration for deterrence, which I think is also an equally important consideration. And so while I will give you each a community control sanction, I'm going to start you off with a 10-day jail sentence. My deputies are in the courtroom, Mr. Brown. Anyways, we'll start you out with a 10-day jail sentence, after which, upon your release, you report to probation, begin your supervision.
At their sentencing in May 2023, Judge Stephen Gall addressed their actions with stern words, comparing them to common criminals who use their skills dishonorably. He imposed a 10-day jail sentence, 18 months of community control, probation, and a $2,400 fine. Both men received a 3-year suspension of their fishing licenses and were ordered to forfeit Kaminsky's boat and trailer. The scandal prompted immediate reforms in tournament oversight, including routine fish inspections and use of metal detectors at weigh-ins. But Kaminsky's legal troubles didn't end there. In 2023, he faced unrelated charges in Pennsylvania for illegal deer hunting and later pleaded guilty to forgery in a separate matter. While some charges were eventually dropped, the damage to his public image deepened. Runyon and Kaminsky have served their jail time, though they are now barred from tournament fishing and carry the label of convicted felons. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.